My name is Thomas Michelenko, and I'm an intervener in the Penn East pipeline. And my farm was taken off the list when it was put on a neighbor's farm. But I've been farming in Delaware Township for 68 years, and since I've been a child, and I farmed out my brother and son. I farmed 2,000 acres of hay in Delaware Township and Kingwood Township. The Penn East pipeline is currently going through 9 of the farms that I farm under these circumstances, and it takes about 3 years just to plant hay to get a good crop, not with any pipeline on them. I'm also presenting a map of another farmer named Robert Fulper, who lives on block 701 and 802 in Amwell Township. He has a monitor on his Case IH combine, which monitors the crops. This monitor is used here to show you a yield on a Texas Eastern 20-inch pipeline, which was put in 1941. The yield has never recovered. This is 75 years, and this is an economic let's see, where am I here? Okay. To the farm. The previous, well, let me see. It takes a economic effort to the farm. This, beyond doubt, that Penn East claims that the crops get better, which they do not. It's false. There are many communities built into this. I'm having a little hard time reading this. There are many, because I didn't write this, I'm sorry. There are many falsities that have been in this community, and all the hay that I have on my farm is documented by the FSA office, and I have yields to do this over many years, and the cost, I don't know how I will get invested in this loss of the farms. There is also issue in the complete of FERC that soil and land preparation is possibly the stones have to be removed, the fields have to be leveled, you have to have lime, fertilizer, seed rate, and damage to the topsoil is impossible to replace. I do not see how you can possibly get topsoil back after it has been taken off. Most of the farms I farm, the paths will be cut down the middle of the farm, and my tractors weigh about 7 tons. It will be impossible to cross over while they're doing the pipeline. They are coming into the agriculture community is not addressed. Penn East is intimidating farmers and signing up to say, if you do not sign up now, you will get less for your land. This is not so. A lot of people have signed up. They're also saying, but this is not so. The bullying and the punishment of our punishment of our community. A rubber stamp protects Penn East and encourages the intimidation which was undergoing the farming community and my family. Income in the security of my family and the variability of maintaining a farming community.
Thank you.
Good morning. I'm Megan Hollering. I'm from North Hartford Maple in northeastern Pennsylvania. I'm here today because last spring, as a result of decisions made by FERC, Williams Corporation caused devastating damages to my family's land in New Milford, Pennsylvania, through an abuse of eminent domain power for the purpose of building the Constitution Pipeline, a 121-mile-long natural gas line running from Susquehanna County, Pennsylvania to Schoharie County, New York. In December of 2014, FERC granted Williams a certificate of public convenience and necessity, despite vocal opposition from landowners, businesses, and environmental advocates. The comments made to FERC focused on the significant negative impact the project would have on the communities and the areas it passes through, as well as pointing out the lack of necessity for the project due to existing infrastructure and intended exportation of the natural gas. FERC determined these concerns to be insignificant, so Williams was granted the power of eminent domain to seize land for the Constitution Pipeline. Additionally, Williams was given possession of the condemned properties prior to compensating landowners. In March 2016, Williams had not yet obtained all of the permits needed to begin construction of the Constitution Pipeline and had no chance of meeting their December 2016 in-service deadline. Despite this, Williams requested a partial notice to proceed from FERC, which would allow non-mechanized tree felling in the right-of-way. My family and numerous other landowners submitted comments to FERC asking that the tree clearing wait at least until all of the permits for the project had been obtained. We own a small business, North Hartford Maple, and we use the forest on our land to produce maple syrup, sugar, and candy. Williams was asking for permission to cut down more than 300 mature maple trees, 3 acres of forest, in the middle of our production season without our permission, without an appraisal of the forest having been completed, without compensating us, and without certainty that the reason for the destruction, the Constitution Pipeline, would ever even be built. We asked FERC to deny the request and prevent the damage, at least until they had obtained all the permits to build the pipeline. In January of 2016, FERC granted the partial notice to proceed in Pennsylvania. As a result, on March 1st, despite our opposition and protest, Williams came to our property, escorted by U.S. Marshals with assault weapons. In 3 days, they clear-cut a 300-foot right-of-way through the forest behind my aunt's home, felling hundreds of ash, oak, and cherry trees and our maple trees. Despite only having possession of the right-of-way, Williams demanded an additional safety buffer to deter protest. This denied us rights to another 150-foot corridor on our property, including our sap processing area and our backyard. 2 weeks later, the December 2016 in-service date, the reason for the need to cut trees immediately without waiting, was extended by FERC to 2017. 2 months later, the New York State DEC denied Williams the 401 water quality certificate, the last permit they needed to begin construction. Constitution Pipeline will never be built, and the destruction will serve no purpose. Thanks to FERC, my trees have already been cut. My home, my business, my family has already been harmed, and it can never be undone. FERC needs to be held accountable for their decisions, and it needs to happen now. Thank you.
Good morning. Susanna Glidden, North Salem, New York. Stop the Algonquin pipeline expansion. FERC's system, including non-compliance with NEPA regulations and omission of health, environment, and valid safety reviews, is entirely rigged against us and our democratic process. FERC recklessly approved expansion of Spectra Energy's Algonquin pipeline in AIM to a massive 42-inch diameter high-pressure transmission line headed for export from Canada next to Indian Point Nuclear Power Plant, based on a flawed risk assessment. When asked by thousands of New York's highest officials to halt it, while New York conducts an independent risk assessment, FERC refused. An AIM resolution passed by towns and 3 county governments with science-based measures to protect our health, safety, and environment, FERC dismissed. A huge gas build-out is underway, fragmenting forests with loss of trees, ruining our air with huge, hideous toxic emissions, water and soil with radioactive waste from pigging stations, impacting us, wildlife, communities, and property values. AIM brings huge quantities of Marcellus shale gas, high in radon, and cancer-causing daughters polonium-210 and lead-210. FERC is impermissibly segmenting from AIM Algonquin's 2nd and 3rd expansions, Atlantic Bridge and Access Northeast. Under NEPA, these 3 projects must be reviewed together for accurately evaluating extreme cumulative impacts on health, safety, and environment. The unjust practice FERC industry and state Title V air permits use of subtracting rural air credits from proposed compressor emissions, allowing way above safe limits of contaminated air, must also be abolished. Concerned citizens jump through every FERC hoop, spending our lives and money docket commenting on segmentation, lack of public convenience and necessity, unfair eminent domain, grave review omissions and insufficiencies, hiring experts, all denied or ignored in this shameful review sham of chasing down the FERC rabbit hole. We registered to sue and requested a rehearing in yet another losing game after FERC approved AIM at Indian Point, putting at risk 20 million people, including New York City. Instead of their expected denial within 30 days, FERC issued a tolling order, buying unwarranted time to stall while construction continued. FERC timed their denial many months later, so the hearing for our D.C. Circuit Court of Appeal will occur after the pipeline is completed and operational. These ruthless, underhanded tactics seem criminal because they're premeditated and harmful to people and environment, and fatally so to the atmosphere. Methane emissions at drilling sites from compressor and meter stations, condensate tanks, pipeline valves, wells, and joints exacerbate global warming 86 times greater over 20 years than carbon dioxide emissions. FERC's rigged system, rife with conflicts of interest, prevents legal recourse and is empowered by corrupt states taking large industry contributions and issuing lax permits. FERC is a rubber stamp agency and rogue, overseen by nobody and an affront to our democracy. The U.S. Congress must conduct a full GAO investigation of FERC. And finally, corporate greed is not a recipe for human survival. Hydrofracking and its distribution infrastructure should be criminalized as part of the penal code for the ecocide and planetary destruction it causes, and those facilitating it fined and thrown in jail as Class C felons. Thank you.
Hi, my name is Alissa Bradley. I'm the energy organizer for Clean Water Action. I'm reading testimony on behalf of Ryan Talbot from Allegheny Defense Project. When FERC approves a pipeline project, the next step in the administrative process is the filing of a request for rehearing. If you want to challenge FERC's decision in court, you must first seek rehearing in front of FERC. Under the Natural Gas Act, when FERC receives a request for rehearing, it has 30 days to either grant or deny that request. It's under 15 U.S.C. 717RA, you know. If FERC fails to grant or deny the request within 30 days, the request is supposed to be considered denied, allowing the aggrieved party to petition the Court of Appeals for relief. FERC, however, has developed an Orwellian tactic in which it issues an order that purportedly grants rehearing, but only for the purposes of further consideration of the request for rehearing. Pursuant to these orders, commonly referred to as tolling orders, FERC grants itself an indefinite extension of time to consider requests for rehearing. Unfortunately, several courts of appeals have said as long as a tolling order remains in effect, aggrieved parties cannot seek judicial relief. This puts landowners and environmental groups at a major disadvantage because FERC often allows pipeline companies to proceed with construction while the agency allegedly further considers matters raised on rehearing. For example, out of 21 natural gas certificate proceedings approved since 2009, the average response time to a request for rehearing was 240 days, well beyond the 30-day time limit in the Natural Gas Act. In many of these proceedings, by the time FERC lifted the tolling order and formally denied rehearing, thus permitting aggrieved parties to seek judicial review, large portions of the project were already constructed. In other words, FERC's tolling orders are not used to allow the agency to further consider matters raised in requests for rehearing. Rather, these tolling orders are used to deny the public meaningful judicial review of FERC's decisions. These tolling orders are contrary to the plain language of the Natural Gas Act. If Congress wants to provide FERC with the power to extend the time period for considering rehearings, it would have to do so. It would have done so in the past. Congress, however, said FERC has 30 days to grant or deny rehearing. Otherwise, an aggrieved party can seek relief in court, and FERC cannot be allowed to interpret the Natural Gas Act to grant unto itself powers that Congress did not provide. The court decisions that have upheld these tolling orders in the past are decades old and must be revisited. Moreover, these decisions involved other aspects of FERC's jurisdiction in the realm of economic regulation. In those cases, an aggrieved party could be made whole again by a refund. That is not the case in the Natural Gas Act proceedings, where property rights and environmental protection is at issue. In such cases, when FERC issues a tolling order and allows pipeline construction to move forward, it should be considered a denial of rehearing, and aggrieved parties should be able to seek immediate relief in the Court of Appeals. Thank you.
My name is Nancy Van, and I live in Peekskill, New York. I'm a retired Wall Street lawyer, and for the last 3 years, I've had an unexpectedly close encounter with a pipeline. The Spectra AIM pipeline, FERC docket CP 1496. It's kept a low profile, so not everyone knows about it. Not low physically, however. It's 42 inches in diameter, which is about the height of a 5-year-old child. It's used eminent domain to take property we own, cutting down 313 trees and wrecking a wetland, all without independent review. From the onset, I was told we probably wouldn't be able to stop the pipeline, the project. After all, the Federal Energy Regulatory Commission, FERC, has only turned down one application in 40 years, but I was determined to try. There are many reasons frack gas pipelines shouldn't be built, but the most important reason for stopping this pipeline is its proximity to the Indian Point nuclear power plant, a mere 25 miles north of New York City on the banks of the Hudson River. You'll hear about the plant's potential 50-mile fallout radius from nuclear expert Paul Blanche. But we know that the AIM pipeline greatly increases the probability of a Fukushima on the Hudson catastrophe that could make New York City uninhabitable for millennia. So why did FERC approve the AIM pipeline? First, they relied on an environmental review by a company with a serious conflict of interest you'll hear about later. They failed to even plausibly evaluate a risk assessment from the Nuclear Regulatory Commission, an agency with no expertise in pipeline safety. And FERC ignored all of our objections during the scoping period and our comments to the draft and final environmental impact statements. They also ignored letters from our senators and members of Congress. They ignored letters from our governor and 4 New York State agencies. In fact, FERC ignored letters and submissions from elected officials at every level of government in the 4 impacted states, New York, Connecticut, Rhode Island, and Massachusetts. The commissioners weren't even willing to listen to my remarks about the pipeline's danger as I was forcibly dragged out of a nominally public FERC meeting just for trying to explain. True to form, FERC rubber-stamped the AIM approval. Then the City of Boston, the town of Dedham, Riverkeeper, and our own coalition of 28 groups and individuals filed rehearing requests. FERC ignored them all for more than 8 months, while the pipeline construction proceeded rapidly. No one is even allowed into court to challenge the validity of an approval until FERC has responded to a rehearing request. And of course, FERC eventually said no. Our federal lawsuit is finally proceeding, but the AIM project is nearly finished. So 3 unelected FERC commissioners have enabled the destruction of life, land, and safety across the U.S. without any accountability. FERC must be investigated before it's too late, not just for us in New York, for our country, our world, and our very survival. Thank you.
Thank you, Nancy.